This is Michael Popok, Legal AF, with breaking news and analysis about abortion rights and women's right to choose under attack once again. We got a judge in the Northern District of Texas, a federal judge, Trump appointee Matt Kacsmaryk, who's about to make a decision that's going to ban in all 50 states the use of the safe and approved FDA pills for abortion, mifepristone, and have it banned across the country. What does that mean? The majority way that women today obtain an abortion is not in an abortion clinic since the Dobbs decision by the U.S. Supreme Court in Alito's pen that ripped away a woman's right to choose that had been enshrined in the Constitution for over and determined by the Supreme Court to be a constitutional right for over 50 years. Women, by and large, now get their abortions through prescribed medication, FDA-approved, home-delivered in the safety and security of their own home. Now, Judge Kacsmaryk, who before he took the bench, you should know this, before the judge was a judge, just to show you his right-wing MAGA bona fides, he was the deputy general counsel of a far-right group, the First Liberty Institute, whatever that means, which has as its position papers, and you can look it up, as Joe Biden likes to say, he has position papers against LGBTQ rights, transgender people rights, abortion, and contraception. In fact, Judge Kacsmaryk, before he was judge, made the following statement, I guess against progressive Democrats. He said that secular libertines, I haven't heard that word in about 100 years, secular libertines sacrifice children for their erotic desires. That's the judge, ladies and gentlemen, that's sitting in Amarillo, Texas, all by his lonesome. And that's why all these cases get filed by the right-wing MAGA in that courthouse, because there's no judges they got to worry about. There's no wheel that has to spin. The only judge that's going to come up is Judge Matt Kacsmaryk, Trump appointee, 2019, with all those views that I just outlined. And now, just as he had things in front of him like LGBTQ rights that he totally eviscerated in his courtroom, even though the Supreme Court, even the right wing, says that they exist, contraception for minors, he completely banned, and all of these things. Now he's about to ban 50-state ban on a woman's right to use an abortion pill that's been approved by the FDA for over 20 years. Wasn't by accident that it ended up in front of them. MAGA right-wing groups, in this case, some sort of far right-wing anti-abortion medical association and some anti-abortion doctors who don't have standing, judicial standing at all to bring the case. And if you don't have standing, you get kicked out of court. The only way you can show standing is if you have an individual, particularized injury to you that's different and distinct from everybody else. Well, this pill approval's been on the books for over 20 years. So what do the doctors say? Oh, well, maybe in a hypothetical world that doesn't really exist, some future patient who took a pill and had an adverse reaction is going to have to come to me for medical care. And what am I to do? I don't want to do that. I want to make sure it's federally banned. That is not a particularized or a fairly traceable, as the case law says, injury back to the approval of the drug 23 years ago to give these yahoos standing. But they don't care because standing doesn't matter to Judge Kacsmaryk. He's going to do a half a paragraph analysis that says they've got standing. Now let's get to the merits of the case, which is exactly what an Article 3 federal judge is not supposed to do. If they don't have a plaintiff with standing in front of them, that case gets dismissed right then and there. But since Kacsmaryk wants to make policy because he's a judicial activist, the very thing the Republicans clutch their pearls and say, oh, we don't do that. Judges don't make law. Yeah, then why are you going to Judge Kacsmaryk in Amarillo, Texas? Also, because he sits in the Fifth Circuit. The Fifth Circuit, so right-wing that one of its panels just last week declared that the 30-year federal ban on people who are the subject of restraining orders in a civil court for stalking, harassing, threatening their loved ones, intimate partners, and children, they have the right to continue to keep their guns. Federal law said they didn't, that those groups of people that had a restraining order against them couldn't also have guns. And the Fifth said, nope, that's inconsistent with the Supreme Court decision recently about the Second Amendment. And so they can go get guns and load up against their intimate partners, and we don't care. That's the Fifth Circuit that we're talking about. Now, look, Judge Kacsmaryk, 95, 98, or 100% chance he's going to rule and try to impose a 50-state ban. Department of Justice is going to have to intervene in that case, continue with that case, take an emergency appeal, maybe even skip the Fifth Circuit, maybe go to the U.S. Supreme Court, but probably with a pit stop at the Fifth Circuit. They'll probably get a loss there because of the nature of the right-wing radicalism on the Fifth Circuit. And then they're going to have to take a hot bench right over to the Supreme Court and try to get an emergency ruling out of that right-wing Supreme Court, who's going to have to decide what are the ramifications and limits of their decision in Dobbs, written by Alito back in May, about whether, does that mean that there can be a ban on the FDA's approval of abortion pills? Let's make it simple. Just because even this right-wing Supreme Court thinks there's not a woman's right to an abortion enshrined in the Constitution, although every Supreme Court dating back 50 years said the exact opposite, that doesn't mean that pills that allow for abortion federally approved can't be used by women. Just because it's not in the Constitution doesn't mean you don't have the right to use it. If it's safe, if it's approved, whether it's CBD or gummies or marijuana or Viagra or any of the other medications that are out there for men and women and others and LGBTQ, if it's FDA approved and it's safe, they should be able to ingest it and take it. You don't have to look there's no constitutional protection for Viagra use. It doesn't say, or heart medication or other enhancement drugs. It doesn't say, oh, you have an equal protection right under the 14th Amendment to be more potent in the bedroom. It doesn't say that, but doesn't mean that the pill can't be sold if it's approved by the FDA. So this whole argument should fall by the wayside. Just because it's not in the Constitution, according to the right-wing Supreme Court, a woman's right to choose, doesn't mean they can't use pills to accomplish that same task. But we're going to find out, and this is going to be something that we need to closely follow. And federal judges and progressives that are looking for ways to find a woman's right to choose, whether it's in state constitutions that are different from federal constitutions, about life, liberty, happiness, about personal privacy. State constitutions also have their own versions that were passed and approved by their own citizens that may have the right to choose buried within there. And that's where progressive groups are going after state houses, state legislatures, state constitutions, and state Supreme Court justices to get rulings in their favor, that even if there isn't a federal right that's recognized state by state, that there is a right to choose. And that is the very issue. Moving on to the federal court in District of Columbia, this is a great bookend to the Kacsmaryk case that I just discussed. We've got Judge Colleen Kolar-Catelli. Remember that name, Clinton appointee. She already struck down the ban successfully, the ban that Trump put in place while he was in office against transgenders serving in the military. She just recently had a very assertive decision in her sentencing of one of the Jan 6 defendants, telling him to his face during sentencing, you got your right to First Amendment expression. You don't have a right to an insurrection. That Judge Colleen Kolar-Catelli. And what she has said in a criminal case that's sitting in front of her, that's brought by some anti-abortion activists, including the founder and leader of an anti-abortion group, who was arrested just before the Dobbs decision came out, who was arrested for protesting and stopping a woman's access to abortion clinics in and around the D.C. area. That group, including the founder of that group, have said, well, there is no constitutional right to an abortion, Madam Judge, and therefore you can't criminalize my denying access to something that's not constitutionally enshrined. Let's stop for a minute. Just because a right is found by the right-wing Supreme Court not to be in the U.S. Constitution doesn't mean that a federal law, which is on the books, banning people from denying other human beings and citizens access to abortion care, it doesn't follow that it's therefore no longer a crime and the federal law falls away because there's no longer a link to the Constitution. Newsflash, there are hundreds of thousands of federal laws and regulations that are not linked to constitutional rights in the U.S. Constitution. If you thought that only Congress passes laws that match rights that are in our very small, narrow U.S. Constitution, then you failed civics class in high school and in grammar school, and you didn't watch Schoolhouse Rock, because that's not how that works. So there are hundreds of thousands of laws that are not linked back to the Constitution, and one of them on the books is a law that criminalizes people from preventing access to abortion clinics. Just because the Dobbs decision said under the 14th Amendment there's no constitutional right to an abortion doesn't mean all federal law about abortions and abortion access suddenly becomes, poof, by magic, by alchemy, gets ripped off the books and decriminalizes all of these behaviors. But you know what? I give credit to the judge. The judge says, yeah, you want to go down that route, that you're not a criminal because the constitutional right to an abortion is no longer present after Dobbs, after Alito's decision. And the judge said, you know what, let's brief that issue. And as long as you're briefing the issue for me, and I want to see it in March, why don't you do something else? The entire analysis under the Dobbs decision was under and only under the 14th Amendment. It found, despite vigorous objection and opposition by the Department of Justice and other amicus briefs that were submitted, it found that the 14th Amendment, equal protection, does not have within it a constitutional right to an abortion. And they said it never did, even 50 years ago when Roe versus Wade was decided and all the other decisions that were decided after Roe versus Wade. And the judge told the lawyers in her criminal case, why don't you go look at the 13th Amendment? Because maybe there's another amendment or another place in the Constitution that the Supreme Court didn't brief, didn't analyze, and didn't rely upon to render its decision. And the 13th Amendment, which for those history buffs out there, that's the one that was passed by Lincoln to outlaw slavery. It's against involuntary servitude. If you want to know more about it, go to that great movie with Daniel Day-Lewis called Lincoln, made by Steven Spielberg. It's all about the passage of the 13th Amendment. And the judge here said, why don't you go look at the 13th Amendment, ladies and gentlemen of the law profession, and come back to me and say that if a woman is forced by law to carry a fetus to term, is that not involuntary servitude? Putting one human being in servitude of another, I'm just going to call it being or entity at this point, because of course there is a dispute among religious scholars and legal scholars and all scholars about whether a fetus is a person. The right-wing Christians, which are shoving these laws down our throat, believe it is. But there are plenty of organized religion that doesn't believe that. The Jewish religion, for instance, does not believe that a fetus is a person, and therefore thinks abortion is an appropriate medical care and health care, especially for a woman and her health or life. So all of these Christian right-wing fetus is a baby, fetus is a person based laws are inconsistent with the teachings of other religions and even sectarian or non-sectarian or secular thought about the fetus and its status. But the 13th Amendment is an interesting analysis, and it's been made before. Is abortion is the failure to allow for abortion creating involuntary servitude and slavery with women? Now, the slavery analysis is very interesting and very ironic because it's the same similar analysis that was used by all of the anti-abortion advocates, including Clarence Thomas, who has said that the allowing a woman to terminate an abortion was an abomination on the books of our constitutional history, just the way the earlier decisions that allowed for slavery by the U.S. Constitution was equally a dark chapter in our history. Now we're turning it around. We're putting the shoe on the other foot, and the 13th Amendment may be able to be used to find that there is a woman's right. And this judge wants to hear all about it. There's other places in the Constitution, and the judge wants these lawyers to search through there, write her a brief before she continues to decide whether there's any merit to the argument raised by the plaintiffs, or the defendants in the criminal case, that they can't be prosecuted because there's no longer a federal constitutional protection for abortion. That's where we are with the state of abortion. This week, with Judge Kacsmaryk in the Eastern District of Texas, about to ban a woman's right to choose and use an FDA-approved drug to terminate her pregnancy. And now we've got Judge Colleen Kolar-Catelli, federal court in District of Columbia, telling her litigants in front of her, go back to the drawing board and figure out whether there's a constitutional right to abortion that's in the Constitution, but not in the 14th Amendment. And I'll give you a hint, look at the 13th Amendment in involuntary servitude. We're going to cover this on Legal AF. And if you want to follow me, Michael Popok, do so at @MS Popok, Popok. Reporting. We'll see you on Wednesdays and Saturdays on the Legal AF podcast.
The best part of waking up? MAGA tears in my cup. Check out the new MAGA tears mug, available now at store.MeidasTouch.com. That's store.MeidasTouch.com. It's 100% union made right here in the USA. I know I'm not tired of winning yet. How about you? Get yours today.